Ms. Quirien van Straelen, Coordinator, Legal Advisor, Ministry of Justice and Security of the Netherlands. Nice to meet you. Next to her, you have Mr. Bilal Azhar Khayani, Member of Parliament, Pakistan, Convener, National Parliamentary Task Force on Sustainable Development Goals. Thank you very much. Next to Mr. Bilal, you have Deputy Esther Cuesta from Ecuador, first member of the Legislative Administrative Council, member of the Committee on Comprehensive Protection of Children and Adolescents, PGA board member. Nice to meet you. And from the last end there, from my left side, you have my honorable member of parliament, my colleagues from the Gambia, and then he is also equally the deputy majority leader of the ruling party. He is not any other person than Honorable Abdoulaye Cisse. Honorable, nice to meet you on this panel today. Honorable members, my names are Honorable Kebba Jallow, Member of Parliament from the Gambia, the Smiling Coast of West Africa. So we'll begin the session by inviting Honorable Abdoulaye Cisse. Yeah. The floor is yours. Thank you.
All right. Good morning to all of you. Like the moderator said, my name is Honorable Abdoulaye Cisse from the Gambia. I'll be presenting on the theme, effective cooperation on the fight against impunity on international crimes. I am very much honored to be here today, at least for the first time to be in Pakistan, and also giving a presentation in such forums as well. I will not waste time. I'll just go straight to the presentation. All right, distinguished delegate, esteemed colleagues, it is with great honor and a profound sense of responsibility that I address this esteemed gathering on the critical issue of combating impunity for international crimes. As parliamentarians, we bear the solemn duty to uphold the rule of law, protect human rights, and ensure accountability for the most heinous offenses against humanity. We all know impunity is the failure to hold perpetrators of international crimes accountable. And it is also a corrosive force that undermines the very fundamental of justice and peace. It also emboldens the criminals, perpetuate cycles of violence, and erode public trust in the rule of law. International crimes such as genocide, war crimes, crime against humanity, and transnational organized crime pose a grave threat to global security and stability. They inflict unspeakable suffering on the victims and their families, destabilize societies, and hinder economic development. Combating impunity for international crimes requires a concerted and coordinated effort from all stakeholders across, including the states, international organizations, civil society organizations, and victim groups. No single entity can effectively address the complex and challenges, and these challenges alone. So I think effectively cooperating among ourselves as states, one of the things that we will be able to achieve has to do with gathering evidences and prosecute perpetrators through sharing information, resources, and expertise across borders, which is crucial for identifying, apprehending, and prosecuting those responsible for international crime. One of the examples I highlighted in the address is about the Gambia. My country ratified an act called the Mutual Legal Assistance of 2023. This act is significant. It is a significant milestone in the transitional justice process of the Gambia. you realize that the Gambia, particularly with regards to accountability for human rights violations committed during the past regime of President Jammeh, this law provides a legal framework for mutual legal assistance in criminal matters between the Gambia and other countries, enabling the country to operate with foreign law enforcement agencies in investigating and prosecuting cross-border crimes. When we operate or cooperate together, we will be able to protect victims and witnesses, which is vital to ensure the safety and well-being of victims and witnesses who often face intimidation and repression. We also say when we cooperate, we will be able to prevent future atrocities by working together. We can identify and address the root causes of international crimes and develop strategies to prevent the reoccurrences. So as a parliamentarian, I also highlighted the role of Parliament in this coordination. Parliamentarians have a pivotal role to play in the fight against impunity. As representatives of the people, we have the power to first enact legislations, develop and implement laws that criminalize international crimes and provide for their prosecution, meaning there must be sufficient legislation of these crimes. Countries should ratify without hesitation the Rome Statute to all the jurisdiction, to allow the jurisdiction of the ICC so that perpetrators of these crimes can be prosecuted wherever they may be. Countries also should have provisions in their laws on universal jurisdiction to prosecute perpetrators fleeing persecution. And a clear example of that I highlighted is, an example of this is the prosecution of Jallow, or is a Gambian soldier, a former Gambian who resides in Germany currently. He flew the Gambia because he was involved in a lot of things as well. And the other example I highlighted in the address is one Usman Sonko, a former Interior Minister of the Gambia, who is being prosecuted in Switzerland as well. So the other thing also is to provide oversight. In as much as we must continue to monitor the implementation of international crimes or criminal laws and hold governments accountable for their actions as well. And also raise awareness within our state. We must also educate the public about the importance of combating impunity and mobilize support for victims. Distinguished delegates, the fight against impunity for international crime is a moral imperative and a fundamental pillar of just and peaceful world. I deeply recognize that working together and sharing resources and holding perpetrators accountable, we can create a world where justice prevails and the rule of law is upheld. This can be achieved only if we recommit ourselves to the noble cause and ensure that the victims of international crime receive the justice that they deserve. Thank you so much.
Thank you very much, Honorable Deputy Majority Leader, and for that lucid presentation. Honorable members, we now have Ms. Quirien van Stranden, Coordinator Legal Advisor, Ministry of Justice and Security of the Netherlands. The floor is yours.
Thank you so much. Your Excellencies, ladies and gentlemen, I would like to express my sincere appreciation to our hosts of the Pakistan National Assembly and Parliamentarians for Global Action for your exceptional hospitality and allowing me the opportunity to address you all this morning. And to all of you, the esteemed members of PGA, for allowing me to speak with you. Now, I'm delighted to take part in a panel with such distinguished speakers and hear on the diverse views of what your governments and states are doing for the effective judicial cooperation on the accountability of atrocity crimes.
It is very important for me.
My work may be a bit different than a lot of you here this morning. I work as a coordinating legal policy or officer within the Dutch Ministry of Justice and Security. And maybe to elaborate a bit on what our team does, it works to promote the effective cooperation with the courts and tribunals in The Hague, our team works for the national policy of nationally fighting atrocity crimes. So supports our public prosecution service in doing the cases that they do. And we also focus on the establishment of new courts and tribunals. For example, for the Ukraine, we're working on an aggression tribunal, and that's something our team is involved in as well. Now, this touches, of course, upon a large part of the discussion that we had yesterday, where we were really focusing on the International Criminal Court and the role that it plays in the fight against impunity. And the ICC is a cornerstone in this fight, but it is not the only instrument that we have. So let us also focus on what we can do nationally in our national cases that we fight, as our previous speaker also elaborated on. But let us also not forget that we also have independent bodies such as IIMM, IIIM, and previously UNITAD, which also all play an important role. Now, I will be speaking on the Ljubljana-The Hague Convention, or the LHC, which is a bit easier to pronounce. This is quite a new convention. It was adopted in May 2023 and opened for signature earlier this year on February 14th and 15th. So far, we have 36 signatories of this new convention, representing governments from Africa, South America, Europe, and Asia. But this number of 36 is still quite limited, and it is very important that this number grows, because this is an instrument that allows national authorities to effectively investigate and prosecute core international crimes. Now, as was touched upon yesterday, of course, the ICC was never set up to be able to investigate and prosecute all atrocity crimes going on. That would be impossible. And it's very important also for national investigations and prosecutions to take place, because often this allows for victims and witnesses and the places where crimes were actually perpetrated to be part of the process, which is very important also in terms of justice overall. Now, the convention that we have set up allows for cooperation between states. And this instrument will help states fulfill their obligations, because due to the very nature of these crimes, they require international cooperation. That is a very brief introduction to the initiative, but I will go on a bit longer for you. Now, the background to the initiative is it has been developing since 2011. At the time, the initiative was spearheaded by the Netherlands, Belgium, and Slovenia, which were working together within a body within the EU called the EU Genocide Network. This is a body where investigators and prosecutors come together within the EU to discuss their cases and to discuss how they can strengthen their cooperation. Now, these states were later joined by Argentina, Mongolia, and Senegal, which became the core group to the MLA initiative. Now, practitioners felt that they faced difficulties in their investigations and that it was very difficult to get the evidence that they needed and cooperate with other states. Now, why is this necessary? Scholars have been saying for a long time that the treaty framework to fight impunity was outdated. Mutual legal assistance for genocide, crimes against humanity, and war crimes is what we're specifically speaking on. Now, this is because, of course, the Genocide Convention and the Geneva Conventions date from the 1940s, when there was never an actual framework set up for mutual legal assistance. Now, by contrast, more recent United Nations Convention on issues such as torture and forced disappearances and transnational organized crime contain these detailed provisions on MLA and extradition, including the option of considering the respective convention as the necessary legal basis for extradition. Now, the lack of these adequate treaty provision prevents or complicates or delays these national prosecutions and investigations. And we, of course, all know that these are often very lengthy and complicated investigations in general. Now, this can be due to the factors such as a country can only extradite on a basis of a treaty, or that they require a treaty basis for coercive measures, such as getting information from banks or getting information from telecommunications companies, using wiretaps or performing house searches, which are often measures that are very much required within investigations, but at the same time, it isn't possible for these crimes. Now, in some cases, the lack of this treaty basis has also been used as an excuse by states unwilling to cooperate. Now, with the new convention, states can no longer hide behind that message. There is an apparent broad consensus all over the world that genocide, crimes against humanity, and war crimes must be prosecuted, and that there should be no scope for impunity for these crimes. In order to successfully prosecute these crimes, effective cooperation between states is thus essential. Now, bilateral agreements do not always fill the gap in this regard, because we are often cooperating with states with which we do not yet have a bilateral relationship, or simply because the agreements that you have for bilateral cooperation do not have all the the provisions that would be required for this specific type of investigations. And this was really the background to the LHC. Now, over the years, because as I mentioned, we started in 2011, the core group really focused on gathering support for the initiative. This led to the fact that 80 states from all over the globe supported the initiative. Now, of course, once you have the idea that we need a convention to actually strengthen a type of cooperation, you also need to find a body through which negotiations can take place. Over the years, it was determined that the existing EU, UN, regional fora were not the correct path for the convention, as it would either limit the number of participants because it would be a regional body, and that was not something that we set up to do, or because it was politically impossible to get the support to move through within UN frameworks. Therefore, it was decided that we would enter into negotiations as a standalone convention. So all negotiations for this convention took place outside of a regional or a UN body and was organized by the core group themselves. As we touched upon yesterday, we see that it's very difficult currently in different international frameworks to reach agreement on conventions on and different statements for the typical crimes that we're working on. So this was really the first time that a convention was concluded outside of the frameworks that we're used to. Now, the diplomatic conference took place in Ljubljana, Slovenia, under the leadership of our chair, Silvia Fernandez de Gourmendi. Here, representatives of 53 supporting states and 15 observer states, 11 NGOs, and 7 international organizations. After 2 weeks of extremely lengthy and hardly fought discussions, an agreement was reached on the convention. Now, the LHC is a very lengthy convention. It includes 94 articles, 8 annexes, and is consistent of 8 parts. I won't go through the entire convention with you, but maybe just to point out that on the one side, the convention sets up a framework for mutual legal assistance and extradition that is very modern and very lengthy, but that allows the investigators who are focusing on these investigations to really set up the systems for cooperation that they need. It sets up a framework including modern investigative techniques such as covert investigations, cross-border observations, but also setting up joint investigative teams, which we have seen over the years is very important for these types of crimes, and has been, it requires a legal basis, and that has been set up now. It also includes practical things such as video conferencing, which wasn't often possible for cooperation in the past. Now, states are bound under this convention also by a duty to cooperate. Speaking on the general provisions, so not focusing on the technical aspects, but the more general aspects of the convention includes definitions which are based on the 1998 Rome Statute definitions. It was very important during the course of the negotiations to not change the definitions that are in the Rome Statute, of course, because that would also limit this Rome Statute system that we have set up. Now, we also have an annex system, which includes a provision on optional application on an ad hoc basis, which would go outside of the Rome Statute definitions, but also includes provisions on enforced disappearances, torture, aggression, and the further reaching war crimes definitions that we have outside of the current Rome Statute. Now, the convention also includes an obligation for states to criminalize the crimes covered under the convention and includes a provision on jurisdiction. This deals with the establishment of different forms of jurisdiction. Now, we all know the term universal jurisdiction, and this provision was discussed at length because a number of states were of the opinion that this provision created obligations that go beyond the existing international law. Now, in the end, it was agreed that states could make a limited reservation on this provision as so far as it was not in contradiction with international law and it follows their own existing national legislation. But the current article does include provisions setting up that it would be mandatory to establish jurisdiction. For example, if the perpetrator is a resident or a national of the specific state, it may set up jurisdiction if a victim is a national of a certain state. And therefore, it really sets the stage, this article, in terms of universal jurisdiction, but also allowing the national legislation, of course, to play a role if that would be required. The convention also contains an audere adjudicare provision, making that states have to either extradite or prosecute in order to help prevent the creation of safe havens. Now, this extends the existing audere provisions, for example, the Convention of Enforced Disappearances. And many of you are, of course, aware of the discussions in the UN Sixth Committee on a Crimes Against Humanity initiative. Within the discussions that we had in Ljubljana, of course, the draft articles that already have been established for the Crimes Against Humanity Convention were very much followed in order not to hamper the process that will be taking place within the UN Sixth Committee. Now, of course, I understand that for many of you, this is quite a technical, lengthy, and detailed convention. But what would be important to remember are a few points that I would like to highlight. Now, the LHC is not related to the ICC framework. So states that are not a party to the Rome Statute can also become a party to the LHC because there is no linkage if that would be an issue to your government. At the same time, we do follow the Rome Statute definitions, so states that are a party to the Rome Statute are not hampered in that regard. At the same time, we do, as a core group, want to strengthen the Rome Statute system. And in that regard, of course, the national investigations and prosecutions of these core international crimes are very important in that regard. So it falls under the complementarity principle that was discussed yesterday. Signatory of the convention is still possible until February 14th, 2025. And after this date, states will have to move forward with ratification completely. Now, as a core group, we recognize the need for many states as possible to ensure a robust framework for cooperation. And at this time, though we have 36 signatories, it is very important for more states to become a party to this convention to even strengthen the system that we have set up. The convention will enter into force after 3 ratifications, which is quite a low number, which means that we hope that next year the convention will actually enter into force, as because we just concluded the convention quite a short time ago, states are very much working on the national implementation laws. Now, effective state cooperation remains critical in successfully prosecuting across crimes at a domestic level. And we feel that the LHC is an essential tool in the toolbox, as we like to say, of practitioners. I hope that all of you can play the important role in calling for your government's support for the convention, and also signaling, of course, that it takes time in these processes to move forward with such a convention. Thank you for your time and attention. If you have any further practical questions, I'd be happy to answer them later or outside. And I look forward to the rest of our presentations. Thank you.
Thank you very much, Ms. Quirien. Distinguished honorable members, RICOF defines impunity as a negative attribute to law, and as such, does not see its relevance and necessity. On that note, honorable distinguished members, the next speaker we have on the line is Mr. Bilal Azhar Kayani, MP, Pakistan. Thank you.
Bismillahirrahmanirrahim. Good morning and welcome, first of all, to all the honorable members of the PGA, honorable parliamentarians to Pakistan. I realize this is the second day everyone flew in this weekend, but we in Pakistan are delighted to have you here, to host you here. Other participants, apart from the parliamentarians who are participating in this conference, including the representatives of the International Criminal Court, International Bar Association, people such as Ms. Quirien, sitting to my right, representing the Ministry of Justice and Security of the Netherlands, members of the PGA Secretariat, fellow parliamentarians from Pakistan, fellow panelists, of course, and I would like to also very quickly mention the staff of the National Assembly of Pakistan, Parliament of Pakistan, and PIPs who are facilitating the logistics here. So good morning to you all and welcome. I'm grateful to the PGA for giving me the opportunity to be on this panel and to speak here. I'm a new member of the PGA and I'm glad to be a member of the Pakistan chapter. And I'm grateful for the opportunity to speak as briefly as I can on this very important topic. I'm grateful for the thoughts that have been shared by my fellow panelists so far. So just very quickly, I would like to start by stating that Pakistan believes, as a matter of principle, that there should be international mechanisms to combat international crimes. These mechanisms should be impartial, non-selective, meaning they should not be disproportionate towards some states relative to others. They should be effective, fair, and complementary to national justice systems, which is the principle of complementarity, which has just been mentioned and I believe was mentioned yesterday as well. The mechanisms should be truly independent and free from subordination to political interests. Obviously, I believe thoughts have been shared yesterday regarding the International Criminal Court. Pakistan has its own position on them. And like many other countries, Pakistan has its reasons for not ratifying the Rome Statute. So far, we feel there are concerns related to sovereignty, jurisdictional overreach, and certain concerns regarding double standards as well. For example, disproportionate use of in Africa, and the case of very briefly, I would like to mention this, the case of the US forces violations in Afghanistan, which were put on the back burner then to try and prosecute other crimes later on. So there were concerns which came in during the Taliban regime. And I believe that the US had also placed sanctions on the ICC prosecutor. And subsequently, the stance of the ICC had changed. So these are just some concerns which we have regarding the ICC serving the purpose for this particular subject for fighting international crimes. There are also challenges of universal acceptance of the 193 UN member states. 125, I believe, have ratified it so far, which isn't even at 2/3 of the total member states. My understanding as a student of this subject is that generally conventions and statutes which have a universal acceptance have at least 170 to 180 UN member states which sign up to this. So I've just very briefly highlighted the reasons why not the ICC. But coming back to what is possible, I would like to state that Pakistan is already a party to several human rights instruments, including the UN Charter, the Geneva Convention, which provides a comprehensive framework for the humane treatment of individuals during armed conflicts, emphasizing protection of civilians and those not participating in the conflict. There is also for more specific crimes, there is the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and the Convention on the Rights of Child. But we realize that in addition to these instruments, you need actual mechanisms, enforcing bodies, which are able to actually play a role in on the ground in combating crime. But we feel that for any mechanism to work, first and foremost, the trust deficit regarding dual standards and politicization and selective implementation of international law will have to be addressed. I think that Ms. Quirien just now highlighted a new initiative, which, as she mentioned, has had limited take-up so far because it's in its nascent stages. But obviously, this initiative and others can be reviewed, can be considered by nations. But however, at the moment, this trust deficit is real. It is very grave. The rules-based order, the global rules-based order is seriously fractured or is under threat. I think Gaza, what is going on in Gaza is a good example of this, or is a good example of the double standards that I've mentioned and many people have highlighted. And, you know, it's to me, at least, it's obvious that if the sort of genocide we're seeing in Gaza was happening anywhere else in the world and was being committed by some other state other than Israel, we would have seen sanctions and several other actions being taken so far. That is not to say that the United Nations as an organization and their secretariat has not played its role. The United Nations, the Secretary General has played its role, but the fact remains that the sort of effective combating of that genocide, of that crime, by the existing international rules-based order that should have been expected has not happened on the ground so far. There have been, in the absence of a global mechanism that is universally accepted, there are other ways to combat international crimes with the ad hoc tribunals, which are specific to a specific situation. So in the 90s, we've seen the international criminal tribunals for Bosnia and Rwanda. These are these avenues can be explored until we reach something that is universally accepted. Similarly, joint investigation teams can also be established, where multiple states can cooperate with specific terms of reference and rules of the game or rules of procedure that are agreed between those states for that specific situation, which would be tailored to that specific case in those specific countries and their national jurisdictions. Finally, information sharing platforms should also be explored. This is low-hanging fruit. I believe that this is already being done in multilateral organizations such as the EU, NATO, and the African Union, but I believe that other multilateral organizations can also adopt this, such as the SCO, BRICS, OIC, and so forth. And such information sharing can include sharing of intelligence, law enforcement, obviously, with mutual cooperation, and information relating to the respective judicial bodies of the countries. And then, obviously, capacity building can be carried out mutually to ensure that the national jurisdictions are as aligned as possible, or the national judicial systems are as aligned as possible on international crimes. So with that, I would just like to just repeat by saying that Pakistan believes, as a matter of principle, that there should be international mechanisms, provided that they are impartial, non-selective, effective, fair, they respect the principle of complementarity, are truly independent, and are free from subordination to political interests. We look forward to working with other countries in order to achieve this objective. With that, I would like to thank the Honorable Moderator once again for giving me the opportunity to speak, and to the PGA for giving me the opportunity to be on this panel. And once again, a warm welcome to all the honorable guests who have come for this conference. Thank you very much.
Thank you very much, Mr. Bilal. And the last but not the least presenter would be no any other person than Deputy Esther Cuesta. The floor is yours.
Thank you. Good morning, dear colleagues, legislators from Pakistan, from different parts of the world, the staff of the National Assembly of Pakistan. Good morning also to the officials of the ICC and all the distinguished guests. First, I'd like to thank PGA for allowing me to be here. Our dear Monica, its wonderful staff, Fiona, Frederica, Jennifer, not only for making this possible for us, but also to make it possible for me to be here with you. I would also like to thank the National Assembly of the Islamic Republic of Pakistan, especially to our dear colleague Naveed, President of PGA, and Sherry, President of the Pakistan PGA National Group, for having us here in this 45th Annual Forum of PGA and the 13th Consultative Assembly of Parliamentarians on the International Criminal Court and the rule of law here in Islamabad. So now you'll need the headphones because I'm going to switch to Spanish. Estamos aquí para avanzar en el rol que desempeñamos los parlamentarios dentro de nuestras facultades legislativas en la lucha contra la impunidad de los crímenes más atroces contra la humanidad. Una tarea es crear leyes que promuevan la cooperación efectiva con la Corte Penal Internacional para asegurar que estos crímenes no queden sin castigo. Y es lo que hemos hecho en Ecuador, precisamente de lo que les voy a hablar. Cuando hablamos de derechos humanos, nos referimos a principios básicos que deberían guiar la convivencia humana. Sin embargo, la realidad es que estos derechos se violan a diario, como lo hemos conversado aquí en estos días, en Gaza, el Líbano, el Sahara Occidental, en Kashmir y en tantos otros lugares donde comunidades enteras son víctimas de genocidio y crímenes de lesa humanidad. A menudo estos crímenes son minimizados, silenciados o ignorados por los poderes mundiales. En Ecuador también enfrentamos serias violaciones de derechos humanos. Mi país en este momento atraviesa una grave crisis multidimensional, energética, de violencia, migratoria, de seguridad y de convivencia pacífica. Mientras estamos hablando, en mi país cortan la energía eléctrica por más de 14 horas al día. Después de que Ecuador en el 2016 fue el segundo país más seguro de América Latina con una tasa de homicidio de 5.83, hoy la tasa de homicidio en Ecuador es de 47 por cada 100.000 habitantes, lo que nos ha convertido en uno de los países más inseguros y violentos del mundo. En los últimos 3 años, alrededor de 2.000 niños han sido asesinados, la mayoría de ellos en manos del crimen organizado, es decir, casi 2 niños a diario. Aproximadamente 5 millones de personas viven en pobreza con menos de $3 al día, mientras cerca de 3 millones de personas sobreviven en pobreza extrema con menos de $1.60 al día. La economía de Ecuador es dolarizada. Estos problemas estructurales han provocado a miles a huir. 7 de cada 10 ecuatorianos se sienten forzados de emigrar en busca de trabajo, oportunidades y seguridad, lo que evidencia una sistemática violación a los derechos humanos de millones de mis compatriotas. Esta realidad que les estoy contando nos obliga a replantearnos cómo podemos, desde nuestros roles legislativos, no solo detener esta tragedia, sino también garantizar que todas las personas, especialmente las más vulnerables, reciban justicia, protección y reparación. Es por eso que los parlamentos debemos actuar, asegurándonos que existan leyes que velen por el cumplimiento de obligaciones internacionales en materia de derechos humanos. Y en el tema que hoy nos compete, que permitan cooperar con la CPI en la búsqueda de justicia y reparación. El proceso de gestación de la Ley de Cooperación entre el Estado ecuatoriano y la Corte Penal Internacional, que es casi como un hijo mío, mi segundo hijo, duró 1 año 7 meses, desde que lo presenté el 13 de octubre del 2022 hasta su publicación en el registro oficial el 16 de mayo del 2024, lo cual es un tiempo bastante rápido, considerando que durante este periodo la Asamblea Nacional fue cesada de sus funciones por 6 meses por decreto presidencial. Caso contrario, hubiera sido aprobada en plazos establecidos en la Ley de la Función Legislativa, que es aproximadamente 1 año. El 22 de diciembre de 2022, el proyecto de ley fue calificado por el Consejo de Administración Legislativa. Desde enero del 2023 fue tratado en la Comisión de Relaciones Internacionales y Movilidad Humana y durante su construcción recibimos diversas voces y perspectivas, enriqueciendo el proyecto de ley con aportes de expertos, académicos, representantes de la sociedad civil y autoridades en el ámbito de derechos humanos. El primer informe lo discutimos en el Pleno el 5 de diciembre del 2023, seguido por el segundo debate en el Pleno el 14 de marzo de 2024, donde fue aprobado por unanimidad con 119 votos. Y los que somos legisladores sabemos que eso no sucede todos los días en un parlamento. El Ecuador firmó el Estatuto de Roma en 1998 y lo ratificó en el 2002, comprometiéndose a cooperar con la CPI. Desde entonces hemos incorporado en nuestra legislación interna las normas del Estatuto de Roma como la imprescriptibilidad de delitos graves, el genocidio y los crímenes de lesa humanidad. La Constitución ecuatoriana, en su artículo 80, establece que estos delitos no pueden ser objeto de amnistía y quienes los cometen, sea quien sea, superiores o subordinados, deben rendir cuentas. En 2010, nuestro Código Penal tipificó los delitos contra el derecho internacional humanitario. Y en 2014, el Código Orgánico Integral Penal amplió esta cobertura, estableciendo sanciones para crímenes como el genocidio, la desaparición forzada y las ejecuciones extrajudiciales. El Estatuto de Roma también establece la obligación de los estados de cooperar con la CPI en investigaciones, detenciones y otras diligencias. Y el artículo 59.1 del Estatuto de Roma señala expresamente que los estados parte establecerán en base a su derecho interno los plazos y procedimientos a seguir, que es precisamente lo que hemos cumplido con esta ley. Hasta hace poco, Ecuador carecía de una ley que regulara esta cooperación. Y eso cambió al entrar en vigor la Ley de Cooperación entre el Estado ecuatoriano y la Corte Penal Internacional. Esta ley garantiza la adecuada investigación y enjuiciamiento de los crímenes de competencia de la Corte y las funciones dispuestas en el Estatuto de Roma. Mediante la determinación de competencias de los órganos estatales y los procedimientos que permitan cumplir con la obligación de cooperar y asistir a la Corte. En ese sentido, la ley establece que instituciones como el Ministerio de Relaciones Exteriores y Movilidad Humana, la Fiscalía General del Estado, la Corte Nacional de Justicia, trabajen coordinadamente para cumplir con las solicitudes de cooperación de la CPI, determinando procedimientos y plazos conforme a nuestro derecho interno, como lo manda el Estatuto de Roma. También regula la entrega de personas acusadas, la detención de personas y la obtención de pruebas y otras diligencias en territorio ecuatoriano. Esta ley también desarrolla principios fundamentales para la cooperación con la CPI, como la complementariedad, que hemos discutido, confidencialidad, debida diligencia, protección de las personas detenidas, requeridas, víctimas y testigos, la cosa juzgada y la obligatoriedad de cooperar. Quiero recordar que la CPI tiene un carácter complementario. Eso significa que los estados tenemos la responsabilidad primaria de juzgar a los responsables de crímenes graves contra la humanidad. Si no lo hacemos, la CPI tiene la autoridad para intervenir. Esto asegura que las víctimas obtengan justicia, verdad y reparación. La aprobación de esta ley fue posible gracias al apoyo de Parlamentarios para la Acción Global. Big thanks. Y ahora puedo decir con orgullo que Ecuador ratifica su compromiso en la lucha global contra la impunidad. En Ecuador hemos demostrado que a pesar de la polarización y la persecución política constante que vivimos diariamente, el lawfare, el discurso de odio y la violencia política contra las mujeres, ha sido posible contribuir con el sistema internacional y su democratización, y hacia la universalización del derecho penal internacional en favor de las víctimas. Muchas gracias por su atención.
Thank you very much, Madam. It was a very informative presentation. Now, honorable distinguished ladies and gentlemen, this ends the intervention of the panelists. I would now open the floor for any further questions. I think I will limit it to probably four. Yes. Is it Uganda? Yes, Uganda.
Good morning. A brief story. Among the African tribe to which I belong, there's an old adage that when a friend's hydrocell can be seen, you have a duty to point it out to them. And I raised that because I want to speak to my Pakistani brothers as a friend. And I want to tell my Pakistani brothers, without insulting your wonderful hospitality, that your hydrocell can be seen. Why am I saying this? Pakistan has not ratified the Rome Statute of the ICC. And for the last 2 days we have been here, you have been pointing, accusing fingers at everybody except Pakistan. Can we have a very honest discussion? Is there any way we can convince you, our brothers, our hosts, that it's in the best interest of the entire world, it's in the best interest of fighting impunity and democracy for you to ratify the ICC statute? I apologize if I have offended you. Thank you.
Still respond.
Would
Respond.
you like to? Next, who would like to take the floor? Yes, can you identify yourself, please?
Thank you. My name is Dr. Shazra Mansab and I'm a member of the parliament from Pakistan. My question is addressed to all the panelists, so anybody can answer. I'd like to know if there are any strategies or frameworks in place for victim protection or witness protection when any case comes in the international court, both at home and abroad. And the second part of my question is that there have been questions of how a country can balance its sovereignty with its international obligations. What strategy has the ICC thought of or is thinking of to address that issue? Thank you.
If with your permission, I'll just take the first comment that was mentioned by the honorable parliamentarian from Uganda, I believe. So just to say that the stated position of Pakistan is that the Rome Statute, we have certain reservations regarding it. It is not just about saying no for the sake of saying no. And it is not just Pakistan which hasn't signed up to it. So I believe that generally accepted conventions and statutes have acceptance by at least 170 or 180 UN member states. The figure for this particular statute stands at 125 so far. So it is not just Pakistan which has its reservations. There are several other countries as well. And therefore, and there are examples which include there are examples of jurisdictional overreach. There are examples of double standards which have been committed. And so as soon as those are addressed, either through the ICC itself or through some other mechanism which is globally introduced or accepted, we'd be happy to sign up to that. But that is the only reason. And just to state very categorically, it's not as if Pakistan is the only country. There are several other countries, including, I believe, major countries such as US, China, Russia, as well as India, Saudi Arabia, and Egypt, to name a few of the 60 plus countries that haven't signed up to the Rome Statute so far. So this reservation is shared, it's not just held by Pakistan, but by several other states. Thank you.
I can comment briefly on witness protection in terms of ICC. Of course, I don't represent the ICC, so I would be speaking more from a national side. Yes, the ICC has an extensive witness protection program, and it depends, of course, on the classification of the risk that a witness is under, what type of measures are taken. So the ICC has their own witness protection service. Also, states can enter into agreements with the ICC in terms of cooperating together. And of course, for ICC member states, but also non-ICC member states, they can support the court in their witness protection measures. If countries where investigations are taking place, of course, there's a lot of engagement and cooperation on a national level, but also states that are not party to specific investigations can also support the court by, for example, having witnesses relocate to their territory, because often, a risk, if it's to that extent, is mitigated by someone going to a different location and setting up a new life in that specific context. For the Netherlands, we also have witnesses that cooperate with the ICC, and it of course depends on the level of risk that is foreseen, what type of mitigating measures are necessary or required. For the Netherlands, because of the fact that we are host to the ICC, we have a large volume of witnesses and victims that travel to the seat of the court, where we also, in some cases, are requested to assist in the protective measures in that regard. So it's very much a system that's set up based on determining what type of risk people face, what type of measures must be taken, where we can all cooperate. And in some cases, I'm aware that also the ICC will work with states that aren't party to the Rome Statute, actually have them support people also being protected in that regard. So it's very much a system that depends on all states to assist the court, because of course the court does not have the mandate to actually, operate on the territory all over the world. But I think that they are very effective and extensive in all the measures that are taken in that regard.
Yeah, thank you very much. Any more? Yes.
Honorable.
Sorry. Okay. Sorry.
Sobre la pregunta de la protección de testigos, víctimas, evidentemente es la Corte Penal la que realiza ese trabajo. Lo que hace el Ecuador en este caso, que esperemos que no lo tengamos que utilizar, en primer lugar, lo que hace la Fiscalía General del Estado es localizar a esa persona y ponerla al servicio de la Corte, a disposición de la Corte Penal Internacional. Pero este tema también me hizo recordar que en Ecuador los medios de comunicación son los primeros en enterarse de los procesos penales y de las investigaciones, antes que los mismos denunciados, antes que las mismas víctimas. Por lo tanto, creo que será importante y gracias por la idea, sería importante, y esto me da la idea de que pueda haber algún convenio de cooperación específico con la Fiscalía General del Estado para mantener una confidencialidad máxima, porque están los principios desarrollados, pero de ahí a que la práctica suceda, nos preocupa. Y sobre the sovereignty, la soberanía, no perdemos soberanía, porque el Ecuador, al firmar y ratificar el Estatuto de Roma, se adhiere y acepta la competencia de la Corte Penal Internacional. Entonces, son los compromisos que tienen los estados, que ahora lo que nos toca es cumplir, esperando que nunca tengamos un caso que tengamos que tratar en el Ecuador, en la Corte Penal Internacional. Gracias.
Yeah, thank you for those responses. Yes.
Merci pour la parole.
Yeah.
Bonjour. Je voudrais faire une déclaration, si c'est possible. Je peux une déclaration?
Yes.
D'accord. Déclaration de la délégation du PGA du Burkina Faso au 45e forum annuel et la 13e ACP-CPI. À cet instant solennel du 45e forum du PGA, j'ai l'honneur me choix de prendre la parole devant.
Channel 1.
Après midi.
Wait for the interpretation. Yeah. Wow. Yeah, yeah, I got it now. Okay. Yes, it's there.
Thank you very much. Alex Carlisle from the United Kingdom. In order to retain their impunity, many potential defendants in the cases we're talking about rely upon sovereign and diplomatic immunity. Are the panel satisfied with the proportionality between the Vienna Convention and the various mechanisms that we're discussing in this conference?
Yes, that will be the last one.
Hello, I'm Pedro Neves de Sousa from Portugal Parliament. I would like to thank you for the interventions. And we talk here about the new convention to develop effective cooperation to the fight against impunity. And we're talking about crimes like genocide, like war crimes, like crimes against humanity. But there is a simple question. In the international law, we know a lot of cases that the law is great, but then the application is not great. We know that there are recommendations from the UN, there are conventions, there are treaties, but sometimes some states, for other interests, they refuse to fulfill their obligations. And the question is very simple. In this case, imagine that a state refuses to cooperate. They signed the treaty, but they refuse to cooperate. What is the sanction? What is the consequence? Because in international law, we have this problem. The states, they have normally two faces. One face for the diplomatic and the face for reality. And I'm afraid that in this case, when we talk about genocide, when we talk about war crimes, there is the possibility of the second phase can win to the first phase. And so what is the consequence? I think we need to make a reflection about this matter. Thank you.
I already said it's going to be the last one then. Okay, next. Yes, you can come. Mike, who is having the mic? Yes. Okay.
Thank you very much, moderator, and our panelists for wonderful presentations. My question is to do with capacity building. As International Criminal Court, do we have funds for capacity building? I'm asking this because international cooperation in fighting impunity also involves efforts to strengthen the judicial, investigative, and prosecutorial capacity of national legal systems. Many countries, particularly those emerging from may lack the resources and expertise needed to prosecute international crimes. So we need to be, we need an assurance if we have funds, because we have a lot on our table. I thank you, moderator.
Yes.
Thank you very much, Dr. Evelina Ohab from the IBA. And just a few very brief comments. First of all, in relation to the double standards that were mentioned, and gentlemen from Pakistan mentioned that if genocide was happening anywhere else than Gaza, the response would have been better. But historically, that's not the case. The responses, international responses, have always been very minimal and always too little too late, so to say. And for example, even right now, we are talking about genocide in Darfur, second in 2 decades. And again, the response, we rarely hear about Darfur. And even during this conference, we are talking about Gaza again and again. Darfur was not even mentioned from what I can recall. And in relation to judicial oversight, we heard yesterday and today that of course the ICC is the court of last resort. So if the domestic courts are investigating, prosecuting the international crimes, the ICC doesn't have to engage. Quick example from Nigeria. Preliminary examination was opened in 2010. In 2020 was concluded and the recommendation was, yes, we need to proceed to investigations. But that's when the Nigerian government mentioned that we are conducting prosecutions right now. And the ICC stopped because of the ongoing complementarity assessment that the ICC is conducting. And this is something to always keep in mind, that this work is being done and the ICC is not going to get involved if the domestic courts are doing their job. And last but not least, and again was mentioned that we don't have 2/3 support of the Rome Statute from around the world. I checked very briefly. We are talking right now about 65%. So for 2/3, we are talking about 66.6. We are almost there. But we need to also keep in mind, the state of Palestine is a member state to the ICC. It's not one of the 193 state parties of the UN. But nonetheless, Palestine reached out to the ICC, and after 2 attempts, they became a member state to the ICC, and the ICC is looking into the situation in Palestine. And us saying that, oh, ICC doesn't have the support is also undermining the work and what the state of Palestine is trying to achieve in terms of investigations and prosecutions. And to some extent also makes a disservice to the people of Palestine who are trying to get justice using the International Criminal Court. So just in terms of, if we again focus on the case of Gaza and the situation of Palestinian people, we just need to keep in mind that the ICC is actually the place where the people of Palestine got the place where they could seek justice and accountability. When, for example, they are still just an observer state before the UN. But these are just few comments just to think about as we discuss those important issues.
Very much. Thank you very much. I think it is time now for me to close the doors. Thank you very much. Thank you very much for the wonderful representation. May we please give them a round of applause. Thank you very much.
We answered the questions that were asked still.
Which question?
We had the question on. I can answer it.
There are 2 questions left.
And the one on capacity building.
Yeah, the capacity. Yeah, exactly. Okay. Okay. All right.
Do you want to? I can take up the question that was made last by the honorable member of the IB. So there were 2-3 things that were mentioned. So one, I mentioned that you're right to say that it just at the cusp of the 2/3 threshold, but my understanding is that for such statutes and conventions, even 2/3 alone is not universal acceptance, that for conventions and statutes of this nature that have universal acceptance, it's generally 170 to 180 member states. The claim was not that if 2/3 members sign up, it is acceptable. It is still below that threshold. But the fact is that it doesn't have the level of acceptance that is generally seen for universally accepted statutes and conventions. The second point regarding jurisdictional overreach, my understanding is that whilst this is claimed by the ICC, the fact is that there has been selectiveness in this. So I understand that there are cases, for example, Kenya and Sudan, where certain national jurisdictions or national capacity were overridden and they were rejected. But in the case of Afghanistan, when US forces were still there, their jurisdiction was accepted. Similarly, regarding the double standards, the ICC first prosecuted American coalition forces, or started prosecuting. The prosecutor there were sanctions placed against the prosecutor, I believe. by the US regime. And subsequently, when the new ICC prosecutor came in, they started prosecuting the Taliban crimes and put the US coalition crimes on the back burner. That is not to say that any crimes, specific set of crimes or violations or alleged violations should not be prosecuted. It is just that you cannot be selective by putting the ones that have occurred before on the back burner and to take up the ones that are suitable. So there are examples. These are specific examples related to the ICC. These are examples that Pakistan believes are a deterrent to the acceptance of the Rome Statute. And this lack of acceptance is not just from us, but from over 60 plus UN member states. It's not just Pakistan. Yeah, sorry, I just wanted to, on the comments made by the lady. Thank you.
Yeah, I just wanted to, with regard to the question that he asked about whether there is any consequence for not respecting the law, I'm not sure whether I'll give you the accurate answer for that, because the question seems to be for probably starts from the International Court of Criminal Court, probably to give you exactly what are the consequences for not respecting the law. But as far as I know, even in our national, at national level, when laws are made, if people don't respect the law, there are consequences for that. So that is a good question. Maybe my co-panelists will be able to respond to the questions directly to give you exactly what are the consequences for that. But as far as I am concerned for Gambia, when you have laws at your national level, people don't respect the laws, there are severe consequences for not respecting those rules as well. Yeah.
Qué interesantes preguntas que me dejan con más preguntas. Sobre el tema de las inmunidades en la Convención de Viena sobre relaciones diplomáticas, claro, yo creo que todos estos acuerdos, sobre todo ese, tiene el principio de buena fe, ¿no? Y esperamos que los diplomáticos actúen en buena fe. Lo que sucede, lo que ahora hacemos es que si hay un diplomático en un país que no necesariamente comete crímenes de lesa humanidad directamente, pero está involucrado en acciones en contra de ese Estado, claro, utilizamos el mecanismo de nombrarlo persona no grata, que se retire del país, etcétera, pero valga la pena para revisar también esa Convención de Viena. Y me quedo con esa tarea, que no hayan contradicciones sobre si cumplen o no cumplen los tratados internacionales. De mi experiencia, incumplen todos los días los estados. Todos los días. Ecuador, por ejemplo, ha firmado como 10 y ratificado como 10 convenciones de Naciones Unidas sobre Derechos Humanos, comenzando por la Declaración de los Derechos del Niño, la CEDAW, la Convención en contra de la discriminación racial, etc. Ninguna de ellas se cumple. Todas las recomendaciones de los comités, yo soy parte de la Comisión de Derechos del Niño, todos los días se incumplen las recomendaciones del Comité de los Derechos del Niño. Y precisamente por ello presenté una ley de vincularidad para que exista ese nexo legal del tratado internacional, porque Ecuador es el primero que va corriendo a firmar y ratificar los convenios internacionales. Lo mismo pasa con el sistema interamericano. Pero después, ¿cómo aterrizamos eso a la vida de la gente? ¿Cómo aterrizamos eso como Estado a garantizar de verdad derechos y que no quede simplemente en un bonito documento online? Entonces yo creo que ese es el desafío que tenemos los Estados. El otro desafío que me parece una excelente reflexión es cómo podemos esperar en sistemas judiciales corruptos muchas veces, sistemas judiciales que tienen jueces mal pagados, fiscales que tienen que investigar casos de crimen organizado y los mismos delincuentes le tienen que proponer: te doy $500,000, yo sé dónde vive tu mujer, tus hijos están a tal hora, salen de la escuela, y los jueces aceptan lo que tengan que aceptar, porque si no, el otro resultado es que les matan a sus familias. Entonces yo sí creo que hay un desafío del sistema penal internacional, del derecho internacional, de poder crear mejores capacidades a los sistemas de justicia, porque si no tenemos sistemas de justicia eficientes, eficaces, transparentes, entonces todos los casos pues van a ir a la Corte Penal Internacional y no va a tener la capacidad los 18 jueces que hay en la Corte. Entonces, yo sí creo que aquí tenemos un desafío de trabajar con los estados parte, de crear mejores condiciones en los sistemas judiciales de muchos de nuestros países, que tenemos un largo camino por recorrer. Gracias.
Thank you very much. Yeah, okay.
Thank you so much. And maybe just to comment on the LHC and the question regarding how we could act if requests are not complied with. Of course, that is a very difficult circumstance for any type of convention. For all MLA and extradition, we can find ourselves in circumstances that states do not respond to requests, do not comply with requests, or, deal with them in a manner that is unsatisfactory. Now, of course, we have the formal way that is dealt with within the convention. There is an article on the settlement of disputes. States should enter into discussions or negotiations and can request for arbitration in that regard. If that cannot be dealt with bilaterally, states can move on towards the International Court of Justice that plays an official role. So that's the official framework that we have. Of course, states often also act through bilateral discussions if this doesn't happen, and we have the whole diplomatic sphere of negotiations. I'm not a diplomat, so I don't get involved there. But of course, we often see that if states aren't complying with requests, especially ones that are very politically sensitive, it can take a number of years to actually move through all the procedures that you have to get answers to specific requests. But at the same time, we often see that, things can change within states. And sometimes after the few years, the changing circumstances have led to the fact that states will actually respond to a request and execute it. I think often if these are high-level cases that are very visible, of course, civil society organizations can often also play a role in bringing attention to the non-execution of requests. It's not, specifically how the normal MLA and extradition procedures works, but in these types of cases where we have a heightened sense of awareness of the very political cases, of course, that nature of attention can also play a role. And at the end of this day, in the LHC, if a state does not comply with a request, of course, due to the audere adjudicare provisions, there is an obligation, if they are both party, to actually investigate themselves. It doesn't always bring the results that everyone would want, but at the same time, because we are focusing on this system of not creating safe havens, this is what we're operating in and what we can strive for. And at the end of the day, if a state does not comply with the level that is required, then of course the ICC does come into play, because if it is not taken up in that regard by the national level, then the ICC as a court of last resort can also take on a case. So hopefully this is quite a bit of a comprehensive framework. Nothing is ever perfect in these international conventions, but I think we've set it up as best we can. In terms of capacity building for national bodies, I'm sure Matthias from the ICC can say a bit more about how the ICC has set this up. But I am aware of the ICC is often able to travel to specific states that need assistance if these are investigation states. And at the same time, you do have quite a few civil society organizations that are involved in strengthening and capacity building in that regard. JRR plays a role in this, but there's also many other bodies. It can, of course, be tricky to find the actual organization that has that holds funds, but there are definitely options in that regard available. Finally, maybe on the immunities, I think that's often a very complex question, and it's very much dependent on each government's position, how they are dealing with personal and functional immunities. In terms of the ICC, of course, there's a very clear designation how that is set up, and that is something that we follow. In the course of, for example, discussions that are taking place for the Ukraine, these are still devolving or evolving views. So I think immunities is a topic that for every government, they focus on their own position. But it remains very difficult in this type of work that we're focusing on to see, hopefully, where we will end up. But of course, the Rome Statute is quite clear on that regard.
Thank you very much. I think this marks the end of the panel discussion. So let's give them a round of another applause. Thank you very much. Thank you very much. Yeah, thank you.
We have Honorable Fatoumata Mijai, MP from Gambia, Honorable Mehtab Akhtar Rashidi, MP from Pakistan, Honorable Rose Bai Gadama, MP from Malawi, and Honorable Mariam Suleiman Khail from Afghanistan. Virtually, she'll be joining. And we have Honorable Mariana Barriena, MP from Ukraine. And last but not the least, Honorable Lorraine Mexamalo, MP from Eswatini. I'll now request the moderator of the day to start the proceeding, please. Thank you.
Thank you very much. First of all, I would like to thank the PGA for giving me the opportunity to be in Pakistan for the very first time.
Honorables, thank you. Please be seated. We're starting with the next panel. Thank you very much.
Thank you.
Silence, please. Please take your seats. We are starting with the next panel. Thank you so much. Thank you so much.
Good morning, distinguished honorable members, staff of the PGA, members of the Pakistani National Assembly, and staff of the Pakistani National Assembly. My name is Honorable Fatma Sanjay. I'm a member of parliament from the Republic of the Gambia, and I am privileged here today. It is a great honor to moderate the panel on pursuing justice for international sexual and gender-based crimes. We all know as female MPs, we are passionate about gender issues and want to protect women against gender-based crimes. I am privileged today to have distinguished panelists, the Right Honorable Mehtab Akbar Rashdi, a distinguished honorable member from the Republic of Pakistan. I also have Ms. Rose Bigadama, another distinguished member of parliament from Malawi, who is the chairperson of the Parliamentary Women's Caucus in Malawi. We also have the distinguished honorable Miriam Suleiman-Kal, an MP from Afghanistan, who will be joining us virtually. The distinguished honorable Miriam is a parliamentarian in exile and also a member of the PGA. We also have Ms. Mariana Bardena, an MP from Ukraine. Madam Bardena is also the chairperson of the subcommittee on Ukraine's compliance with international commitments in human rights. She'll also be joining us virtually. And on my immediate left, I have Madam Honorable Lorraine Zamola, who is a member of parliament from Eswatini. Madam Humalo is the chairperson of the Gender and Development Committee, as well as the chairperson of the Tourism. She is also a distinguished member of the PGA. Ladies and gentlemen, distinguished members of the PGA, international justice, we all know, is very important. I am not only moderating today, but my task is also to give you a short presentation on how to pursue international justice. So before I bring in my panelists, I will give that short presentation on pursuing international justice. Pursuing justice is to take action to ensuring that people are treated fairly and that legal rights are protected, and to hold individuals, institutions, or society accountable for any wrongdoings it can. It can also imply working to right wrongs and rectifying past injustices and seeking to create a more equitable and just society. We all know the society we live in now. There is so much atrocities. So seeking international justice is as important as seeking justice in our domestic environment. Rape, sexual violence, sexual slavery, forced prostitution, forced pregnancies, forced sterilizations. I'm emphasizing on these because I come from a third world country and we are less privileged. Certain people are forced into certain things, especially the most vulnerable, whom are the women, are forced into certain crimes that they cannot help themselves to come out of. And sexual-based violences are as widespread as weapons of war and are used as weapons of war in conflicts world over, mainly used by perpetrators to terrorize and mostly to degrade, punish communities, and ethnically cleanse women and girls. Those are the most targeted and they are left with stigmas that if internationally people do not intervene, they will be left destroyed in their whole lives. Ladies and gentlemen, I won't go further, but in my closing, I will go more into details in why we need to pursue international justice for sexually and gender-based crimes. But I will now give the floor to the distinguished Honorable Mrs. Mehtab Akbar Rashini, the distinguished member from Pakistan. Thank you. I'll now give you the floor.
Thank you very much. It's my pleasure to be with my fellow parliamentarians from most of the countries of the world and talking about a very essential issue which actually requires a lot of attention, not only for us, but the rest of the world. And we have also experienced that this crime, which has been committed all over the world, every now and then, is not actually getting the attention which it should have been. Just to start and giving you some information, just a little bit what to and how to think about this crime. The term sexual and gender-based crimes covers sexual violence, including rape and forced prostitution, that internationally signify major violation of global laws. Recognizing sexual violence as war crimes and crimes against humanity, crucial for our aim of worldwide accountability. In 1949, the Geneva Convention identified sexual violence as a basic result of the warfare, yet made the earlier legal framework fuzzy on SGBCs. The Rome Institute of International Criminal Court and the Convention on Elimination of All Forms of Discrimination Against Women, CEDAW, explicitly state that the SGBCs constitute the war crimes and also the violation of human rights. So it is necessary to address such crimes with an aim to maintain the international legal standards while ensuring the protection of human rights and to hold the culprits accountable, ensuring the justice of victims. Now, we are here to deliberate on a serious issue of this grave concern that continues to plague the very fabric of our society. This issue relates to the sexual and gender-based crimes that cover a wide range of acts, including sexual violence, rape, and as I already mentioned. I would assert the need for recognizing sexual violence as war crimes and crimes against humanity. This is very essential to ensure that accountability is carried out on a global scale. I would recall here, as I mentioned, what happened in 1949, the Geneva Convention identified it as a sexual violence, as a basic result of the war crimes. And we are watching here what is happening in forcibly occupied Kashmir, what is happening in Palestine, what happened in Serbia. So we are witnessing all these crimes happening over and over again. But despite of the fact that we have got such an international organization like UNO, like Security Council, and now this organization which is striving hard to reach out and make the other countries feel that they should be participating in addressing such crimes, we are still struggling. We are still striving that we should reach out to all the countries to be on the same platform and think and talk about these issues. It is pertinent to mention here that the effective prosecution of sexual and gender-based crimes not only upholds the international legal standards, but also seeks to ensure timely justice for the victims. Article 7 and 8 of Rome Statute explicitly recognize sexual and gender-based crimes as crimes against humanity and war crimes, respectively, thus enabling ICC to prosecute offenses such as sexual slavery and rape. The ICC's notable success in prosecuting people like Jean-Pierre Bemba and Bosco Ntaganda validates its capacity to establish accountability for war crimes and other sexual violence. The international community has been very unequivocal. This is very important, that we are not in the same platform as we are expecting the international community to address such issues. So, in declaring the sexual and gender-based crimes will no longer be tolerated, and those who are found to be involved in such crimes will have to taste the legal consequences under all circumstances. It is worth mentioning that the International Criminal Court stands as the central pillar in global efforts aimed at prosecuting sexual and gender-based crimes. Its legal framework has been very influential in defining and prosecuting these crimes. However, despite its critical role, the International Criminal Court has been unable to attain the desired goals, mainly due to limited jurisdictional authority, because a great majority of countries across the world are yet to sign the Rome Statute. Under the circumstances, organizations like Parliamentarians for Global Action have come forward to encourage the ratification of the Rome Statute to enable the ICC to prosecute sexual and gender-based crimes as a legislative network representing 132 countries. PGA encourages and supports nations to align their legal framework with the Rome Statutes. It may be noted that United Nations has assumed a proactive role to address the issue of SGBCs, with the Security Council's adopting resolutions 1325 to ensure the safety of women and girls in conflicted zones. Nevertheless, addressing the sexual and gender-based crimes requires a comprehensive response from the international community. Besides, the lawmakers of the member countries can play a significant role by enacting relevant laws and formulating policies that seek to address sexual and gender-based crimes more effectively. While the International Criminal Court ICC provides a crucial mechanism for prosecuting these crimes, its jurisdictional limitations remain a challenge. Universal ratification of ICC is very crucial to ensure effective prosecution of sexual and gender-based crimes. Moreover, countries are required to amend their existing laws to incorporate key principles as given under the Rome Statute in order to enhance national jurisdiction to prosecute sexual and gender-based crimes. It is also very essential to explicitly define sexual and gender-based crimes in national criminal codes and protections for victims and witnesses. It may be recognized that the International Criminal Court serves as primary mechanism for the prosecution of sexual and gender-based crimes at the international level. However, the court's functioning is hindered by the lack of resources and political support. Therefore, to ensure that the International Court carries out its mandate effectively, member states should furnish the required financial and logistical support, having considered the progress made by the ICC and similar groups working for this purpose. So the question is this, that we keep on saying all these things, we keep on bringing to the notice of the world what is happening, and gender-based and sexual crimes are crimes against humanity, but we see very little response from the rest of the world. My question always has been that how come that we give least importance whatever happens with women? Are they not human beings? See what is happening in the war crimes jurisdiction of such countries. They are going through this, whether it is Ukraine, whether it is Palestine, whether it is Jammu and Kashmir. But, we are engrossed in some other international issues. Sometimes I consider it that maybe we have seen the world, when the world has been growing. We consider ourselves the most knowledgeable generation as the world has been moving. But I think the nature of man or the human being is the same. It is just the technology which is changing. If you are cruel, you are cruel. First, you were fighting with your hands, then you had weapons, now you have other weapons to fight. But your nature remains the same. And if the people think that women being the vulnerable physically, I think the times are changed. They can also get the gun in their hands, they can fight. But what about us who are fighting for the human rights? Are we actually doing our work? What is United Nations doing? Here, I think, according to me, you may disagree, might is right. Why? I always question, I being the student of international relations, I ask the questions that why the other nations not challenging the right of veto. Why one country is allowed to say no? The rest of the world is at one side and the one country says, I don't agree, veto. The another country which is equal to them says also, I also get the right of veto. What about the rest of the countries? They are not humans. They don't face these atrocities. So I think that the time has come that our thinking has to be changed. This is a reality that gender-based violence is a very severe and critical and sentimental issue that we have to address this. One can go on and on to talk about this, but then again, of course, the limitation of time, I'll be asking my other fellows to give their position. Thank you very much.
Thank you very much, distinguished. It shows how considerate Madam Honorable is, because she's not only talking about rape victims, she's also thought about widows, because widows also need protection. They have human rights. We will discuss that later. But meanwhile, I'll give the floor to Miss Roseby Gadama, a member from Malawi, who is also the chairperson of the Parliamentary Women's Caucus in Malawi. Thank you.
Thank you very much, Madam Moderator. Greetings, all your excellencies and distinguished ladies and gentlemen. Allow me to start by expressing my heartfelt appreciation to PGA for making it possible for me to attend this assembly. And thanks again to the Pakistan government for the warm reception. It was a tough decision for me to accept the invitation, but I was brave enough to accept it. Now that I'm here, I feel like I should not go back to Malawi. But now back to business. Malawi signed the Rome Statute of the International Criminal Court on 3rd March in 1999 and ratified the statute on 19th September in 2002, making them the 81st state party. I'll give you an overview of the of the fight against sexual and gender-based violence in Malawi. Sexual and gender-based violence is an issue in Malawi, with approximately 1 in 2 women reporting experiencing physical or sexual violence in their lifetime. This alarming problem negatively impacts the health, dignity, and economic opportunities for women and girls across the country. The Parliamentary Women's Caucus Strategic Plan of 2024 to 2028, created by the Women's Caucus members of Parliament Committee in Malawi, has been one of the guiding policies in the fight against sexual gender-based violence. The Parliamentary Women's Caucus Strategic Plan represents a significant commitment to combating gender-based violence in Malawi, outlining a collaborative framework involving stakeholders like Oxfam. And this plan emphasizes legal reform, victim support services, and community awareness of the harmful effects of gender-based violence. Malawi has implemented the National Plan of Action, which aims at addressing gender-based violence systematically. The multi-sectoral approach involves various stakeholders working towards comprehensive strategies focused on prevention and response measures. There are some key initiatives to address the sexual gender-based violence. These include survivor center care, which the World Bank implemented as a project that prioritizes survivors' interests, providing safer environment for reporting and support services. Legal and policy frameworks for the Sexual Offences Act, which was made in 2016. This strengthens legal protections for women and girls, increasing penalties for offenders and improving support mechanisms. Women-led organizations, these organizations connect survivors of gender-based violence with essential services and have played a crucial role in providing case management training and facilitating mobile courts to support victims. Creating healthy approaches to success, in abbreviation CHATS. This initiative, led by Age Africa, provides life skills and gender-based violence awareness to empower young women in Malawi, and also Back to School campaign. This program facilitates the reintegration of young girls who have faced early pregnancies due to sexual gender-based violence, aiming to return them to education. Challenges in fighting sexual gender-based violence include norms and victim blaming. Prevailing cultural attitudes often normalize gender-based violence and perpetuate stigma. This cultural context makes it difficult for women to seek help or report violence. Many survivors face significant barriers and as financial constraints that limit their ability to access legal aid or navigate the judicial system effectively. Underreporting is also another challenge faced. Due to fear of stigma and reprisal, many incidents of gender-based violence remain unreported, impeding accurate data collection and active response strategies. There are also resource concentrates. There is often insufficient funding for implementing gender-based violence interventions, particularly in rural areas where access to services is already limited. Another challenge is early marriage and pregnancy. Many girls are trapped in cycles of early marriage and pregnancy, leading to higher dropout rates from school and economic dependence on abuse partners. Collaboration with international organizations enhances resource mobilization and advocacy efforts. The Spotlight Initiative comprehensively addressing gender-based violence by focusing on prevention and response to Malawi. We have some policies, recommendations, and parliamentary interventions in the fight against sexual and gender-based violence. Strengthening legal frameworks is essential for combating sexual gender-based violence effectively. National laws must comprehensively criminalize all forms of gender-based violence, including sexual assault, domestic violence, and sexual harassment. Effective enforcement mechanisms are necessary to ensure the investigation, prosecution, and punishment of perpetrators. Additionally, the implementation of laws that protect the girls of victims, including access to justice, medical care, and counseling, is crucial for supporting survivors. Promoting gender equality and improved empowerment is vital in addressing the root causes of sexual gender-based violence. Education and awareness campaigns should be implemented to challenge harmful gender stereotypes and promote respect for women's rights, and also supporting programs that empower women economically, as well as ensuring access to education, empowerment opportunities, and financial services is key to fostering economic independence. Furthermore, increasing women's participation in decision-making process at all societal levels helps to transform power dynamics that contribute to sexual gender-based violence. Improving access to justice involves establishing victim-centered support services, including hotlines. Prosecutors and judges should focus on sexual gender-based violence issues and the importance of gender-sensitive investigations and prosecutions, ensuring that investigations and prosecutions on sexual gender-based violence conducted in a timely manner is essential to upholding justice for survivors. Addressing the root cause of sexual gender-based violence requires a multifaceted approach. Implementing strategies to prevent and resolve conflicts peacefully is critical, as conflicts often exacerbate sexual gender-based violence issues. Tackling poverty and inequality helps reduce the vulnerability of women to SGBV. Additionally, challenging harmful cultural and social norms that perpetuate gender inequality and discrimination is fundamental to long-term change. Strengthening international cooperation is vital for a comprehensive approach. Sorry. I'll take it again. Strengthening international cooperation is vital for a comprehensive approach to combating to combating sexual gender-based violence globally. Fostering partnerships between governments, international organizations, and civil society can enhance coordinated responses. Facilitating data sharing and exchange of best practices among countries can also improve overall responses to sexual gender-based violence. Furthermore, holding perpetrators to sexual gender-based violence accountable, regardless of nationality or the location of the crime, is essential for deterrence. Members of Parliament in Malawi have also a crucial oversight role in the fight against sexual gender-based violence. They can monitor the implementation of laws and policies related to sexual gender-based violence, holding government agencies accountable for their response to SGBV cases, investigating allegations on human rights abuses, including sexual gender-based violence, falls within their responsibilities.
Thank you very much, Madam. I think that was a
that's the final one. And also, interparliamentary cooperation is another key strategy for addressing sexual gender-based violence. MPs can collaborate with legislators from other countries to share experiences and best practices, advocating for international cooperation in this critical fight against sexual gender-based violence. Thank you for listening.
Thank you very much, Honorable. I think that was an explicit explanation of what Malawi have done, and we applaud them for the Legal Assistance Act of 2016 and hope that the law is being implemented to ensure that people that need assistance are given the assistance that they need. And it is now time to bring in our virtual participant, Honorable Mariam Soleiman-Kal, an MP from Afghanistan, parliamentarian in exile, who shall be addressing us virtually now. Thank you.
Thank you for having me. To all the honorable members of Parliament, distinguished delegates and allies, I regret not being able to join you in Islamabad today. But let's be clear, the nations that handed Afghanistan to the Taliban need to be held accountable. This is not merely a failure of diplomacy. It's a moral betrayal of the Afghan people, especially its women and children. I want to begin by thanking Parliamentarians for Global Action, PGA, for their unwavering support of Afghan representatives in exile. Your solidarity is not just symbolic. It is essential to every parliamentarian who has spoken out. For Afghan women and children, I extend my deepest gratitude. Thank you all. I speak today not only as an exiled representative, but as someone who has seen the horrors firsthand. The crisis in Afghanistan is not confined to its borders. What happens there today will affect the world tomorrow. This is not just about Afghan women. It's about defending the core principles of human dignity. Let's make one thing clear. The Taliban do not represent Afghan culture. They're a product of an extremist ideology designed and propagated by the ISI. Their version of justice is chaotic, decentralized, and brutal. Each Talib considers himself judge, juror, and executioner. This is not governance. This is organized terror. According to Bishnau survey, led by Mariam Safi and Drops, 67% of Afghan women describe the Taliban's restrictions as a systematic attempt to erase their existence. The most recent ban prohibits women from speaking to one another, even during prayer. This is not merely about silencing women. It is about breaking them, isolating them, and then erasing them from society. But the violence against women doesn't stop with the laws. Many are forced to get into marriages with their rapists, not by law, but by the cultural impunity of the Taliban foster. Child marriages are rampant, stealing girls' futures constantly. 64% of the Afghan women describe this reality as a deliberate system of erasure. And this terror extends to boys as well. Recently, a video went viral that shows a horrifying reality of Taliban indoctrination. A young Afghan boy, no older than 5 years old, stands reciting extremist rhetoric in Urdu while surrounded by adults cheering him on. This is not just about raising a boy. It's about weaponizing a child. It's part of a broader strategy to cultivate a generation filled with hatred, a generation taught to reject democracy, freedom, and human rights as enemies. Within a decade, these boys will become the faces of global extremism. We've seen what happens when extremism is left unchecked. 9/11, the London bombing, attacks in Kenya and Tanzania. The global implications are clear. Unchecked extremism becomes a threat to every nation, not just its birthplace. The Taliban's ideology knows no borders, and in a connected world that we live in today, radicalization spreads rapidly. The Nazis used laws to dehumanize Jews and erase them from existence. The Taliban's laws do the same to Afghan women, stripping away their rights, autonomy, and humanity. This is not merely history repeating itself. It's a modern failure to confront genocide by law. Women's rights in Afghanistan were built over centuries of struggle. They represent the progress of humanity achieved through sacrifice and resilience. To allow these rights to be erased is to betray every single woman who has ever fought for freedom, equality, and dignity. But even in the darkness, resistance persists. We see Afghan women every day standing up in the streets. We have women in Pakistan like Mahrang Baluch, Samidin Baluch, fighting for the Baluch people's rights against the Pakistani oppression. And even recently, we see Iman Mazari, who was recently arrested for supporting peaceful protesters. Their courage is a reminder that this struggle is not just for Afghan and Baluch people. It's a global fight for justice. This is a call to action. Silence, neutrality, and inaction are not an option. Afghan women's struggle is not just about survival. It is about defending justice, equality, and human rights. I close with this poem that I've wrote that voices the defiance and resilience of Afghan women. They buried our words, but our whispers grew stronger. They silenced our prayers, but our faith only deepened. We are not victims, we are fire, and this flame will rise until freedom arrives. Thank you.
Thank you very much, distinguished Honorable Miriam. I think your resilience, your perseverance must be applauded. This is the more reason why we need a united world against injustice. We now give the floor to the distinguished Mariana Bardina, also an MP from Ukraine, who will also be addressing us virtually. Madam, you now have the floor. Thank you.
Dear participants, it is very important for me to address you today. We are discussing a difficult and sensitive issue. How do we protect the victims and survivors of sexual violence that the Russian armed aggression brought against my state and people? This is the 10th year of Russia's war against Ukraine. Since the beginning of aggression in 2014, sexual violence is one of the Russian weapons of war. After the 24th of February 2022, the sexual violence that Russian combatants commit against Ukrainians became much more widespread. We are living through the worst possible cruelty. Nobody thought that a human can torture another human like this, rape, cut off genitalia, and purposefully execute prisoners. Russian soldiers showed us that it is a reality. Today, the Prosecutor General's office is investigating 321 facts of conflict-related sexual violence, but the scale of the war crimes of the Russian Federation is much larger. Unfortunately, I cannot show you the faces of the victims, but I can share 3 of their stories today. First is a story of a young woman from the Kiev region. Russian soldiers broke into the home where she has lived with her family, Her husband got shot outside. She was raped non-stop for several hours while her child was hiding nearby. Fortunately, they were able to escape to another town. The perpetrator has been identified and the case is in the court now. A girl from the Chernihiv region, she, her brother and their grandmother became prisoners in their own home when Russian soldiers decided to stay there. The commander of the Russian unit tried to rape the 16-year-old girl multiple times. He hit her on the head with his weapon and choked her to make her stop resisting. He has threatened to kill her relatives and to let her be raped by his unit. As of now, the perpetrator has been identified and the suspicion has been declared. The third story is a story of a boy from the Kiev region. Russian servicemen raped him while his mother was tied to the chair and forced to watch. The boy stopped speaking after the violence he had experienced. We all believe that Russia has to pay for all the damage caused. At the same time, in the parliament, we are developing legislation to support those who have experienced conflict-related sexual violence. We have already passed at the first reading the draft law on urgent interim reparations to survivors of the sexual violence. These people are in a particularly vulnerable position. This is due to the significant stigmatization of sexual violence and the long-term consequences of the damage. We propose to determine at the national level the necessary amount of assistance and financial support that the survivors will be able to receive immediately. This is necessary to restore their physical, psychological, and household situation. These people were living a peaceful life until the enemy broke into their homes. This evil must be punished. Then the victims will hopefully feel that at least a bit of justice was done. All these war criminals and their political and military leadership must face the International Tribunal and the International Criminal Court. They should receive the highest punishment. This is our common task of honor for people who stand for democracy, the rule of law, and human rights. And only together we can bring Russia war criminals to justice. I want to thank all those who support Ukraine. It is priceless to have such friends. With your support and with weapons for Ukraine, our common victory and victory of democracy becomes closer. Thank you.
Thank you very much, Honorable Berdina. Honorable Berdina is the chairperson of the Subcommittee on Ukraine's compliance with international commitments in human rights and protection. As the chair, she needs to have confidence in international committees and international organizations. Without that hope, without that trust, there is no hope that these unjust atrocities being exercised in Ukraine will ever stop. And let us not forget, it is not only in Ukraine. The distinguished honorable has also mentioned Kashmir. We have seen what is happening in Gaza. We have seen what is happening in Sudan. I am from the Gambia. We lived in 2 decades of dictatorship with the world watching and applauding. So I think the need to pursue international justice is as important as it has ever been. Ladies and gentlemen, the last but not the least, I will now give the floor to Honorable Lorraine, who is from the beautiful kingdom of Eswatini. She is the chairperson of the Gender and Development Committee, as well as the chairperson of the Tourism Committee. Madam Lorraine, you have the floor. Thank you.
Thank you, Madam Moderator. I am from the Kingdom of Eswatini. We were formerly Swaziland. Distinguished guests, honorable colleagues, Greetings from the beautiful kingdom of Eswatini. I am honored to sit here this morning and panel with these great women. And I'd also like to thank PGA and Pakistan for hosting us. It has been a great pleasure. I was a little worried when we first sat here and we were a panel of all women, there was no men. So when we came, I was pleased because men are usually the perpetrators of SGBV. Pursuing justice for sexual and gender-based crimes, reflections from the kingdom. Pursuing justice for sexual and gender-based violence crimes necessitates a comprehensive and collaborative approach. While progress has been made, significant challenges persist. Ongoing advocacy, community engagement, and policy reforms are critical for creating a safer environment for all. By addressing the root causes of SGBV and supporting victims, significant strides towards justice and equality can be made. Sexual and gender-based violence is a pressing human rights issue in the kingdom, profoundly impacting many individuals, especially women and girls. This presentation explores the current landscape of justice for SGBV in Eswatini, highlighting the legal frameworks, cultural challenges, and the collaborative efforts of various stakeholders working to address the critical issue in Eswatini. Because each and every week, we see stories of SGBV on our daily newspapers. The legal framework. Eswatini has made strides in creating legal framework to combat SGBV through our Sexual Offences and Domestic Violence Act of 2018. However, significant gaps remain, especially in enforcement, along with limited access to legal recourse for victims, which obstruct effective prosecution and the delivery of justice. There are still parts of the Act which have not been enforced. For example, the enforcement of sexual offenders register and allocation of special courts for SGBV and the establishment of digitized case management and SGBV information systems. The Kingdom of Eswatini has adopted the National Strategy to End Violence and Costed Action Plan 2023 to 2027 and has adopted a 3-year accelerated and prioritized plan which seeks to fight SGBV. The Legal Aid Office has been set up in the beginning of 2024. Eswatini is very rich in culture, and due to the patriarchal society we live in, it is most of the time misused. Cultural attitudes in Eswatini often contribute to the stigma surrounding SGBV victims. Many individuals fear being victimized and therefore discourages them from reporting the SGBV that they experience. Traditional gender norms can further complicate these matters. People prioritizing family reputation over the individual safety of the victims. There is need to strengthen educational initiatives aimed at transforming these perceptions and raising awareness about SGBV to combat these harmful norms. Challenges in pursuing justice. There are several barriers that hinder victims to receive justice in Eswatini. I'll speak firstly about the barriers to reporting. Victims often face intimidation, fear of retribution, and the lack of trust in the justice system. The stigma associated with SGBV can further prevent individuals from coming forward to report these crimes. Judicial challenges. The judiciary often suffers from a lack of resources, leading to prolonged delays in legal proceedings. Low conviction rates for sexual and gender-based crimes reveal systematic issues within the law enforcement and the judicial system. Poor coordination within and amongst SGBV response agencies. This leads to delays in the case finalization and referrals between law enforcement, medical and justice and justice service providers. Insufficient capacity. There is need to train specialized personnel to deal with SGBV, especially in evidence gathering, forensic analysis, and dealing with survivors in a sensitive manner. The role of NGOs and civil society plays a pivotal role in advocating for SGBV victims. They provide critical services such as legal aid, counseling, and shelter, and lead community awareness campaigns to educate the public and to promote victims' rights. It is therefore important and effective collaboration between NGOs and government for a unified approach in tackling these SGBV crimes. The government of Eswatini has undertaken various measures to address SGBV, including the development of national policies and action plans. However, effective enforcement and commitment of existing laws are essential for meaningful progress. It is important for policy improvements, which include strengthening victim support services and strengthening the legal framework to ensure comprehensive protections. Government has also, access to support services is crucial for the recovery and reintegration of SGBV victims. Resources such as shelters, counseling, and legal assistance play a pivotal role. A multidisciplinary approach that incorporates healthcare providers, social services, and legal advocates can foster a more supportive environment for victims and also to enhance overall outcomes. Thank you, and thank you for listening to me.
Thank you very much, Honorable Lorraine. I think it's quite evident that the panelists have illustrated the need to pursue international justice for such crimes. In as much as the ICC and other international courts focus on systematic types of violations, I think the gruesome act, the gross violations of sexual-based violence gives it the importance for it to be seen as international crime. If we, as members of parliament, realize the lack of resources, the lack of trust in our own domestic courts, I think it is quite evident that victims and survivors need the support of international courts. We now open the floor to questions to our quite exquisite panelists, I would say. I think this is the best panel so far in this forum. Thank you. Kenya? Who has the mic? Kenya, please.
Thank you for being the best panel. according to the moderator. My question goes to any one of you. You've made a very good presentation about your country's situations on sexual and gender-based violence. But I'm just wondering, I didn't hear any of you, sorry, I missed the first presentation, so maybe you spoke to it, but I didn't hear the others speak about the emerging technology facilitated sexual and gender-based violence. Because now you find a lot of cases of sexual and gender-based violence that use technology in issues of trafficking in persons, and even learned sexual and gender-based violence that even some people, when they abuse somebody, then they share. And then women in political spaces, where people even use AI to create a perception that you are involved in some sexual act, and then they share nude photos. I didn't hear you speak to that. And secondly, the other question is maybe your take on the issue of a growing trend, which I think one of the, Mariam, I think, she alluded to it very little, about a young man who is being groomed to be violent again online. And we are seeing new and emerging spaces of toxic masculinity. When we're in a room like this, it is difficult for a man to stand and say it is okay to rape a woman. But in technology, we are now seeing people saying very terrible things and encouraging each other and normalizing sexual abuse. And what are your countries maybe doing? Do you have a legal framework, or what is your responses in your countries? Thank you.
We'll take two more, and then they will give you the opportunity to answer the question.
Let me actually take in the first question because I'm not.
Thank you very much. I really had a very simple question that I wanted to ask of the panelists. In the discussions we've been having, I haven't really heard much, and I'm interested in hearing about the collaboration across the aisle and across gender in terms of gender-based violence and GBV in particular. We've spoken a lot about government programs. I wanted to just get an insight from you of the challenges and success of collaboration across the aisle and across gender inside of the Parliament. Thank you.
Dr. Evelina Ohab, thank you very much for your presentations and the specific focus on gender-based violence, conflict-related sexual violence. And indeed, conflict-related sexual violence never receives the attention it requires. And this, even though in recent years we've seen the use of rape and sexual violence across all. And in the words of Dr. Mukwege, it is also because rape does not only break the victim survivor, but also the whole community. It affects the whole community. And this is also why perpetrators choose rape and sexual violence. And I don't have a question, but I wanted to pay tribute to the Gambia. And this is because the Gambia took Myanmar before the ICJ. And this was for violations of the Genocide Convention. And among those atrocities, rape and sexual violence was one of the horrific crimes perpetrated against women and girls, including gang rape. And of course, we talk a lot about the ICC because, of course, that's the topic of the the conference, but ultimately, of course, ICC is not going to solve all world's problems. I think we need to emphasize that. But there are also other avenues for justice and accountability, and indeed turning to the ICJ to rule on violations of the Genocide Convention in the case of Gambia versus Myanmar, I think is also an important step towards justice and accountability. So I wanted just to emphasize this important case.
Thank you. Since that wasn't a question, so I will give one more person the opportunity to ask a question. Thank you.
Thank you very much. I sincerely want to appreciate the panelists for expanding on this topic. My question is about the Lanzarote Convention, the Council of Europe Convention on the Protection of Children Against Sexual Exploitation and Sexual Abuse. I haven't heard any panel stress on that. I wish to find out whether is there any work in our respective countries regarding the ratification of this convention? If whether something is being done in our respective countries. Thank you very much.
Lastly, thank you very much, Ms. Moderator. Well, it's more of a comment and a question intertwined together with regards to maybe perhaps a statement that was made by one of your virtual participants. I mean, the topic we have here is pursuing justice for international sexual and gender-based crimes. I fail to fathom where the comment, of course, we are the host country, and in a multilateral setting, I think direct attacks on the host country should have been avoided. It's very unfortunate that one of the panelists who's actually joining virtually, and I fail to understand where she actually, got this information from, or how she could come to this conclusion in raising or pointing fingers, or making allegations for that regard. I think it'd be perhaps quite appropriate if we stick to the topic rather than actually pointing fingers, especially at the host country. Thank you very much.
So that is well noted. Thank you so much. And before giving the floor to the panelists, I would acknowledge the applaud given to Gambia, where I am from, but also to inform this August gathering that Gambia has also just done the TRRC, and we would appeal to the ICC and all other institutions, the PGA, to make sure that recommendations of the TRRC are also implemented. Because before, in my language, they say, I will translate it directly, before you water other people's gardens, you should try at home, because we have been through a lot for over 2 decades as well, and we need a special tribunal to also make sure that victims and survivors are really compensated and see justice. I'll now give the floor to the panelists. Thank you.
Okay. After. All right. Thank you, Madam Moderator. I'll try and answer the second question, which was about collaboration. If I heard correctly, was between males and females towards advocacy on the fight to end SGBV. I'll give a classic example of what is happening in Eswatini. We have male members who champion the fight to end SGBV, and it has really helped because it works as peer-to-peer, and men listen to other men rather than men listening to women. And Eswatini, we are mostly rural and mostly conservative and mostly traditional and religious. So the government has collaborated with traditional leaders, religious leaders, to end the fight against SGBV, such that when traditional leaders like chiefs meet the community, they discuss the effects of SGBV, and that has helped tremendously in the fight to end SGBV, because traditional leaders and religious leaders, we know that they command authority, and also the community trusts their leadership more than anyone else. And also, I'll try to take the third question from Cameroon. He spoke of the ratification of the child. Eswatini has done that. That's why we have really less or no child marriages, and actually a lot of our girls, a high number of girls, are registered and are schooling. We face no child labor, and the Sexual Offences and Domestic Act that I told you about of 2018 has been deemed one of the harshest laws of the kingdom, and that has helped tremendously in fighting sexual-based violence in the kingdom. And it is one of the best laws in the country. Probably most of you can copy or learn from that one. You can just Google it. Thank you very much.
Thank you very much, distinguished. You now have the floor if you have anything to answer. Thank you.
By listening to our fellow speakers and also the questions, I'm as representing Pakistan. I believe that Pakistan has everything believes in that there should be our national interest and principles should be followed. We follow our own national interests and principles. And why Pakistan has not yet ratified the Rome Statute? Due to these considerations, that there should be impartial and effective international mechanism. Should be impartial and effective mechanism. Here we are living in the world where we ourselves are taking sides of one power or the other power. So we are looking, I think, including this organization, that there should be some impartiality in dealing with the issues. An issue like gender and sex violence is a human rights issue. So how come that we have not yet been able to create the impartiality of ICC? Here we are in Pakistan, we believe in the call that there should be an ongoing dialogue among nations. It should be continued. What are the hindrances? Why we are actually not standing with each other, knowing that something wrong is going on? We know what is happening in the world, but we don't raise our voice. In the garb of defending ourselves, Israel, not ourselves, Israel defending itself is attacking on not one country, but 2-3 countries. Why we are so quiet? So this impartiality is lacking. So we in Pakistan believe that we call for ongoing dialogue among nations to reform international legal frameworks to ensure they uphold the principles of justice, independence, and fairness in all states. So that is what my stance is here, my opinion and my country's opinion.
Honorable Mehtab, before we give our virtual participants the floor, I give the floor to Roseby Gadama to answer the few questions that might have been directed to her. Thank you.
Thank you very much. I'll answer one of the questions from the honorable member from Kenya, because she asked 2 questions. I'll take the online or AI sexual gender-based violence. Indeed, it is a global concern. and Malawi does not work in isolation. I can say Malawi has started doing something on capacity building on this topic. However, the pace is at a very slow pace because of some of the challenges we face in Malawi. And I can say that in Malawi, most of the people, both in urban and in rural areas, do not own smartphones. If I may put it in percentages, maybe I would say about 20 to 30% of the population own the smartphones. So it doesn't mean that it's not a concern, but according to the priorities of our problems, we are doing it at a slow pace. Thank you very much.
Thank you very much. Like I said, we are going to give the floor to our virtual participants, but before we do so, we are going to give the floor to Mr. Sherfal, who is from the ICC Trust Fund, to give a brief presentation as well, just for a few minutes. Thank you.
So thank you very much. Just a few words. As a man, I cannot sit in this panel and with my mouth shut. So just adding a few elements to the discussion. Haven't prepared a presentation as such, but just want to indicate that there is so many layers when it comes to the harm suffered by victims of sexual and gender-based violence. Victims do suffer the crimes to start with, after which they need to live with the shame, being stigmatized in addition, and sometimes when there is an existing support, that benefit, the fact that they are benefiting from that support may create an additional layer of victimization for them. I want to highlight two things. One, which has been briefly mentioned, which is that boys and men are also victims of sexual and gender-based violence. And it's very important not to, to avoid leaving that of the debate. We cannot compare gravity of crime suffered. Sometimes boys and men suffer crimes that are not strictly limited to, and being a bit graphic, a physical crime as such, but crimes that may also involve the use of tools such as weapons, for instance, in addition to the fact that the shame that they may suffer, depending on their culture, lead them not to speak about it at all whatsoever, making it very difficult to detect, very difficult to prosecute, and very difficult to address in the end. So in trying to ensure that SGBV crimes are properly prosecuted, it's also important to take into account that dimension. At the International Criminal Court, there is an existing SGBV prosecution policy, as well as a gender persecution policy, which have been updated, that take into account those dimensions. But maybe being a bit provocative, I want to ask simple question: prosecuting SGBV crimes, yes, then what? Victims continue living with the harm they have suffered, physical injuries, psychological trauma, as well as the impact that this has in their socioeconomic situation, and simply the social circumstances in which they are living. The ICC has been created as a two-leg entity. The ICC prosecutes, but states had the clear-sightedness to realize that we cannot just prosecute and that's all. And that is why they have created the Trust Fund for Victims, to address the harm suffered by victims. And as part of in the execution of our mandate, we have been addressing largely beyond the existing cases. Every time there has been an investigation. Victims of crimes falling under the jurisdiction of the court, boys or men that have suffered sexual gender-based violence. Something important was mentioned, and I just want to maybe give a brief idea of how some of our programs are organized when it comes to SGBV. It was indicated that it's important to include men as well when it comes to addressing SGBV. In the context of the Central African Republic, for instance, we had a program that was addressing specifically women, and we've gone through the whole process of addressing their psychological harm, physical harm, as well as socioeconomic harm. But we realized that that was not working because the person were going back in the same environment in which they were still being stigmatized and the mentalities were a certain way. So in implementing the program, what we have tried to do was simply to include men that were within their communities and at the source of that. That's what we have called positive masculinity. We have realized that by including those men in the implementation of our programs, that the impact that it had ultimately on the victims was very different. Thank you very much.
Thank you very much for that great contribution, bringing it to our attention that gender is not only about women, but the fact that mostly we focus on women is because they are the most vulnerable and at times the most affected. And I now give the floor to our virtual participants to answer some few questions that have been directed to them. And I appeal to our participants that we do not encourage direct attacks to our nations. Thank you very much.
Thank you again for an opportunity to speak. I wanted to address the first question in regards to AI and the internet and technology and how this is affecting all of our nations and especially victims of sexual violence and human trafficking. In a country like Afghanistan, which is very disconnected from the world, the danger lies in the fact that there is no human rights watch, there is no watchdog seeing what happens. And majority of the time, whenever a young boy or a woman is a victim of sexual violence, if they go and they report it, the repercussions from that might be worse than the actual act of violence that happened to them in the first place. So we're stuck in a really bad place. What's more dangerous is how the internet is connecting people, because we're living in an interconnected world today, and spreading this ideology throughout the world in a rapid pace. So what's happening in Afghanistan, I want to reiterate this, 2 young boys and 2 young women and older women and all women, over 20 million women, during the same time, this is not going to be contained in Afghanistan. It used to be contained in a certain area on the other side of the Duran line where there was over 40,000 madrasas built. But within the last 3 years, thousands of madrasas have been brought into Afghanistan. And within these madrasas, there is indoctrination into a very dangerous ideology. And before there was a military mechanism that was controlling where it could go, the overflow, which was Afghanistan. Now that it's in Afghanistan, the overflow is not going to be controlled. And this is why I'm speaking. I'm not just speaking for Afghanistan. I'm speaking on behalf of the people of the world. I'm speaking because I care about the people of Pakistan. And to address the last brother who spoke to me, I have the utmost respect for the people of Pakistan, but I do hold the military establishment accountable for what they've done to their own people as well as my people. And to not speak about this would be against my own integrity and against what I swore on the Quran for standing up for my people the day I took my oath. So again, I pray for peace for all of our people from all of our countries. And I hope there's an end to sexual violence against women. I hope that our brothers stand next to us and fight this fight with us. And I'm sure that we will win, because there is no world without unity and without peace and without these extremist ideologies that are destroying our world, not just my nation, but the entire world. But take my nation as an example. Take the plight of Afghan women as an example, because this is not going to stay in Afghanistan. It will happen in Pakistan. It will happen in Africa. It will happen in Europe. It will happen in the United States. And we're seeing it happen. The extremist ideology is spreading. And this is not just my fight. It's you guys' responsibility as well to raise this voice and fight these ideologies that are harmful for the entire world. Again, thank you for having me.
Thank you very much. We now have our last panelist to address the questions. But before we move, I've seen a hand persistently up, and I think it is just right that we give her the opportunity. I think she has something important to say. So I'll give you the floor for just 1 minute. Thank you.
Thank you very much, Madam Moderator. Let me congratulate our panelists for wonderful presentation and responses. Can I proceed? Okay, thank you so much. Actually, first of all, I would like to thank our panelists for their presentation and responses. Let me go straight to the point. In as far as the issue of gender-based violence is concerned, I really appreciate the efforts made by various countries in addressing the issues to do with gender-based violence. And I would like also to remind the participants that poverty is another challenge to our women. It's also violence against women. Our women out there are suffering in poverty, and we cannot sit here and celebrate that we have policies in place, we have laws in place that are safeguarding the rights of our women. We should also think and strategize on how we can promote our women economically. I have few suggestions. Number one, I would like to ask the PGA to come up with special programs that could empower our women, like networking and partnership with other NGOs. At the same time, there's a need of international cooperation. We need to engage our women with international organizations like World Bank. Recently, I've listened a presentation from the World Bank. The World Bank has set aside a special program for women empowerment, particularly economically. So we should also engage the World Bank to promote our women, at least to address the issue of poverty. Have a lot. I'll share.
We have the resolutions this afternoon. So
No
if you
problem.
can bring all those contributions for them, they shared the resolutions yesterday for us to have a look at. And if you have any suggestions, I would advise that we direct it so that it can be included in the report. Thank you so much for these brilliant suggestions.
Thank you so much, Madam Moderator. I will share with the Secretariat.
Thank you so much.
Thank you.
Thank you. And before we proceed, we have a participant on Zoom from Egypt, Madam Amina Saber, who would want to give contributions as well. The panelist from Ukraine, unfortunately, is not available to answer questions because he did a video presentation, but we give the floor to Amina Saber from Egypt. Thank you.
Yeah, thank you so much for giving me the floor today. To very quickly, I just wanted to highlight the catastrophic gender-based violence events which the Sudanese women has been facing over the past 2 years since the onset of the conflict. I just want here to highlight the extreme importance of getting women in peace women in peace missions also on this floor, along with the nexus of health, with what it has to do and add to the gender-based violence events which are happening in Sudan. I come from Egypt, and we have received lots of refugees, actually millions of refugees coming from Sudan. And I can't tell you to what extent the amount of humiliation, the amount of harm, the amount of extreme anger which they come with. This is gonna take the whole humanity to a horizon of revenge later on. You can't imagine the grudge which is held inside these hearts of these women who flew their home countries, who were exposed to rape, to sexual assault, to extreme violence on too many levels. For this, I call to intensify the penalties on these kind of crimes, especially with the special attention to what is happening in Sudan right away. Currently, this is really happening on daily basis. It's a difficult issue to tackle, and we need missions on ground. What the court could do is actually sending more of missions on ground to understand and unlayer such complicated vulnerabilities, to tackle them either on the parliamentary side or any legal intervention in a proper way that takes or heals a bit of such revenge and such harm where women are exposed to extreme levels of violence and of humiliation to their human dignity and to their sex and everything else. Thank you for giving me the chance.
Thank you very much, Honorable Amina. I think this clearly emphasized what the panelists have been saying all along, that these are gruesome crimes. They need to be internationalized. They need international justice, but we can't finish everything, because if we are to go through this, we will be here for until kingdom come. So we are appealing to all of us as lawmakers to go back and make sure that the Rome Statute is not only signed, deposited, but ratified. I am sitting here as a Gambian. We signed since 1998. We have still not ratified, but be rest assured, I have my deputy majority leader here. Even though I'm not in the government, we are a united parliament. We will make sure that the Rome Statute is signed, not only signed, but deposited as soon as possible. Thank you very much. And I hope you will take home a lot from this panel. Thank you.